Welcome to the third part of International Humanitarian Law for Public International Law. This is Dr. K. Sangeeta. In spite of the advantages of the Nuremberg tribunals, the crime against humanity continued to be considered as an accessory to war crime. There were many used to protect the inhabitants of the country from the authorities of an occupying power and had to have nexus with the war crimes or crime against peace. Allied Control Council's adoption, a wider definition of crime against humanity, was an important milestone. Although the Control Council only had national jurisdiction in Germany, the definition marked an advance in the understanding of these crimes, atrocities, and offences, including but not limited to murder, extermination, enslavement, deportation, imprisonment, torture, rape, or other inhuman acts committed against any civilian population, or the persecution on political, racial, or religious grounds, whether or not in violation of the domestic law of a country where it was perpetrated. Commission on International Law in 1996, the draft Code of Crime Against Peace and Security to Mankind, elaborated at the request of the General Assembly of the United Nations. The draft code, like crime against humanity, are defined as any of the following act when committed in a systematic manner or on a large scale and instigated or directed by the government or by any other organization or group: murder, extermination, torture, enslavement, persecution on political, racial, religious, or ethnic grounds. In continuation, institutionalized discrimination on racial, ethnic, or religious grounds involving the violation of fundamental human rights and freedom or resulting in serious or disadvantaging a part of the population, arbitrary deportation or forcible transfer of population, arbitrary imprisonment, forced disappearance of persons, rape, enforced prostitution, or other forms of sexual abuse, other inhuman acts which severely damage physical or mental integrity, health, or human dignity, such as mutilation or severe bodily harm. Article 18. Ad hoc Tribunal for Rwanda and Yugoslavia, or the Statute of the International Criminal Court. Article 5 of the Statute of International Criminal Tribunal for the former Yugoslavian established its competence to try those accused of following crime against the civilian population in times of armed conflict, where murder, extermination, enslavement, deportation, imprisonment, torture, rape, persecution on political, racial, and religious grounds, and other inhuman acts. In the Tadic Appeals Chamber judgment of Yugoslavia, establishment that demanding proof of armed conflict reflects the reach of the customary law concept of crime against humanity, since after Nuremberg trial it is no longer necessary to establish a nexus between crime against humanity and war crimes or a crime against peace. The Statute of International Criminal Court incorporates the Yugoslavian approach. Any of the following act when committed as a part of widespread or systematic attack directed against any civilian population with the knowledge of the attack as according to Article 7 subclause 1 and in addition to the crime listed by the International Tribunal on Yugoslavia includes deportation or forcible transfer of population, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity, persecution against any identifiable group or collectivity on political, racial, national, ethnic, cultural, religious, gender, or other grounds that are universally recognized as impermissible under international law, enforced disappearance of persons, the crime of apartheid, or other inhuman acts of similar character, intentionally causing great sufferings or serious injury to body or mental or physical health as mentioned in Article 7 subclause 1. The statute of the International Court or Tribunal of Yugoslavia contemplates crimes of infraction derived from Article 3 of the Protocol of the Geneva Convention. The International Criminal Court contemplates conduct in the realm of both international and internal armed conflict, which can be prosecuted at an international level. The International Criminal Court statute makes special mention of the character of this conduct must have in order to fall within the court's jurisdiction. Article 8 subclause 1 established that the court shall have the jurisdiction in respect of war crimes, in particular when committed as a part of the plan or policy or a part of the large-scale commission of such crimes. The International Criminal Court statute makes reference to the grave breach in Article 3 of the 1949 Geneva Convention and the other grave breaches of law applicable to the non-international conflict within the framework of the international law. The statute lists the infraction, specifying that they must be committed against persons not participating directly in the hostilities, including members of the armed force who have given up their arms and those who are out of the combat due to illness, wound or detention or any other reason, as according to mentioned in Article 8 to C 1 to 4 and E and 1 to 12. The applicability of the statute of internal conflict is restricted in respect of situation of disturbances or internal tension such as mutinies, isolated and sporadic or acts sporadic where it is taking place simultaneously in different places, an act of violence or other acts of similar character. Now we will see genocide. In agreement with Article 2 of the Genocide Convention, genocide means any of the following act committed with the intention to destroy in whole or in part a national, ethnical, racial or religious group, as such killing members of the group or causing serious bodily or mentally harm to the members of the group. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in the whole or in part. Imposing measure intended to prevent birth within the group. Forcibly transferring children of the group to another group. Crimes against humanity. There is no single definition of crime against humanity, although they include what is said in ICC, ICTY and ICTR statutes, which is the Yugoslavian, Rwanda and the Criminal Code statutes. Taking the element common to these three statutes, the following definition can be constructed. Crimes against humanity must be committed against civilian population. Crime against humanity must be committed on a massive or systematic scale, and it must be intentional. Conduct constituting a crime against humanity includes murder, extermination, slavery, deportation, torture, rape, persecution for political, racial or religious motives or other inhuman acts, crime against the law or the custom applicable to armed conflict. These crimes constitute war crimes in relation to the Hague Convention governing war and its limit, as well as the Geneva Regulation which concern protection of war victims. Breaches of Hague Convention and other regulations of war. The numerous conventions and protocols codifying the law of war originates from 14 Hague Conventions drafted between 1899 to 1907. These regulations apply to international conflicts and mainly relate to the type of arms used in the conflict and to certain prohibited arms. Breaches of Geneva Convention. The Geneva Convention distinguishes between grave breaches and other breaches of the convention. Report on special rapture on systematic rape, sexual slavery-like practices during wartime. Crime, rape in regard to requirement of penetration in the definition of rape. The special rapture wrote in her final report, although this report retains penetration in the definition of rape, it is clear that the historic focus on the act of penetration largely derives from the male preoccupation with assuring women's chastity and ascertaining the paternity of children. It is important Nevertheless, to emphasize that all the forms of sexual violence, including but not limited to rape, must be condemned or prevented. If you see para 24, we can understand that. When you see crime, sexual slavery, the special rupture defines slavery as the status or condition of a person over whom any or all of the powers attaching to the right of ownership or exercise, including sexual access through rape or other forms of sexual violence. Implicit in the definition of slavery are notions concerning limitation on autonomy, freedom of movement, and power to decide matters relating to one's sexual activity. Para 27 and 29, you could understand that clearly. So, public international law is divided into international human rights law, international humanitarian law, and international criminal law. So, this order could be seen in the hierarchical form how it is working. Distinction between international humanitarian law and international criminal law. Not all violation of international humanitarian law constitute war crime. Not all IHL treaties criminalize violation. However, certain violation of IHL could be categorized as crime through customary law. Individual criminal responsibility for violation of international law. International humanitarian law focuses on action and obligation of states and governments or parties to a conflict. I thank everyone who has patiently listening this part 1, part 2 and part 3 of the international humanitarian law for public international law. Thank you.